Thank you, Nnamdi.
Only one place to start.
Headlines. Only one
place. It's on every paper.
Every paper. I mean, just when we thought the live streaming of the court proceeding was over, next thing we segued into the U.S. Congress discussing Nigeria as a country of particular concern. And of course, Mazi Nnamdi Kanu's case came up there as well, with some of them describing it as a travesty of justice. Now, just to get something straight, Barrister Ejike, let's start with you. When we're looking at Mazi Kanu's sentence, life imprisonment, 20 years, 5 additional years, is this a 50-year sentence? Because we understand life imprisonment to mean 25 years. Has it changed?
No. From my understanding, life imprisonment is life imprisonment. It's not 20 years, it's not 25 years. It's life imprisonment. Because the statute prescribes a death sentence. And it was by the judicial discretion that he reduced it to life imprisonment. It's a different situation where the originally statute prescribes a life imprisonment, and then you can then say that the life imprisonment equates to 25 years or 20 years or whatsoever. But in this instance, it is a life jail, a lifetime.
I mean, it's quite shocking, isn't it? I mean, that's a long time to be in prison. But people have also talked about the fairness. When you saw the court proceeding yesterday, do you think that that was a fair judgment, or was it a travesty of justice?
It's a difficult question to answer. One is that the defendant, Nnamdi Kanu, did not help matters by not having adequate legal representation. And so he opened the door for whatever shenanigans that the prosecution. I don't want to dwell on the judge. Let me just say the prosecution, because when you present the judicial arbiter with just one set of information, what do you expect him to do? Okay, the town has been rife with stories about how the judgment was preconceived or not. But of course, there was really nothing else for the judge to have written, because there was absolutely no countervailing facts from the other side. A judge is supposed to weigh. That is, if you look at the symbol of justice, you have a scale where you weigh two sides. This particular judge, despite all his bad press, really had nothing on the other side of the scale to weigh. So it was an easy ride for the guys who wanted to railroad Nnamdi Kanu to wherever, But I myself was not down. I was not downcast. I was rather upbeat. I saw it as just one hurdle out of the way. It's not the end of the road. I have always maintained that this matter was, from the start, was never a legal issue. It has always been a political issue. So when you are trying to apply legal solutions to a political problem, it gets you nowhere.
Kanu's team is still exploring the legal options. Yeah, the Court of Appeal.
They're saying, and I mean, that's where I was going to come as research, because yesterday, if I remember, the fear was that because there was no defense entered, there might not be grounds for appeal. Does he have a grounds for appeal now?
Yeah, he can initiate grounds for appeal. He can go through the judgment of the Federal High Court and then pick up his own grounds of appeal. Nothing stops him from appealing, even though that he did not enter into defense. But my worry is that if you would be intending to continue to explore legal options, why didn't you enter your defense? You would have entered your defense if you had wanted to continue to. Let's take, for instance, you know very well that no matter what happens, they will put you to prison. Let's take, for instance, you know no matter what, let's take for that this prosecution is targeted to put you to prison. You put your house in order. You bring a robust legal representation. You challenge the case of the prosecution. He gave us list of witnesses that he was supposed to call. He even categorized them. Everybody was waiting for this, robust defense that will actually shape the case of the prosecution. But at the end of the day, it never happened. And I was saying that had it been he kept this case alive a little bit, probably it would have given stakeholders the opportunity to continue to negotiate for out-of-court settlement. It could have been one of the items that the contenders can add in one of the options that Trump could give Nigeria. It could have opened up a whole lot, an avalanche of options for him to to get out there. But that doesn't mean that his case is totally bad, because he's going on appeal. I wonder where that appeal will rest on. And again, he's also...
I mean, if we're looking for where to set the appeal on, well, there were a couple of things people picked up yesterday. And I want to look at this on the headline of Daily Independent, under the major headline, the first rider there, Abaribe describes Kanu's life sentence as preconceived. Now, throughout yesterday, I was in all sorts of discussion groups. Lagos State, people in Lagos, Igbo people, Anyama State creation groups, like 10, 15 WhatsApp groups, all discussing the same thing. And there was one recurring theme. And somebody said it in one group, and it caught like wildfire. Everybody kept saying, I noticed everybody kept saying it. Said, this judge is reminding me of 2023, where a judge is reading as if somebody wrote the judgment for him. That he was stammering, he was stuttering, and he was reading some points as if he had never seen them before, as if he did not write it for himself. Then, secondly, some things we know not to be true because we were there. For example, that Nnamdi Kanu and IPOB organized the NSAS protest were still put as part of the charges, and he was still accused of it. And more or less now they've tied NSAS to IPOB. That's from being a lie of propaganda, it has become fact of law. So these two things now, is there anything in there that can be put on appeal? Because automatically what you're saying is that everybody involved, you say IPOB is terrorist, IPOB was NSAS. You can now use this to go after anybody involved with NSAS and say that they are IPOB, no matter their tribe, and that they were working with terrorists. So is there more danger to this than we're seeing that? And is there anything that might be grounds for an appeal? Okay,
the problem is still the problem, because appeal court is all they have is an appellate jurisdiction. It's not a trial court. Appeal court will not call witnesses. Appeal court can only evaluate the witnesses and the strength of the evidence during hearing. They cannot call any new witness. So let me give you an instance. If the prosecution allegedly accused Mr. Mazi Nnamdi Kanu spearheading the NSAS and linking him to plots of violence and all the rest of them, what did he say about it? What did Mazi Nnamdi Kanu enter into the witness box and say, I never did this, look at where I was? Was there any alibi? Did he challenge the case of the prosecution? So what do you expect the honorable judge to say? I rightly concur with what my learned brother said, because you gave the judge no alternative to weigh the evidence, to throw one thing out or to remove another, or to say that by the case of the defendant, you understand that the allegation of the prosecution could no longer hold waters. The judge was not given any other option other than to hook, line, and sinker, take what has been presented by the prosecution and base Mr. Mazi Nnamdi Kanu's conviction on it.
When
I just wanted to add a caveat, so that the listeners do not misunderstand. We're not saying, for instance, that in any given situation where a criminal trial goes on and the defendant or an accused person did not enter a defense, that accused person at the conclusion of the trial cannot appeal or has no basis to appeal. No, that's not what we're saying. You can appeal. For instance, in this Mazi Nnamdi Kanu's case, I'm not part of the legal team. I have not studied that judgment. I've read the judgment, but reading the judgment and studying the judgment are two different things. Okay, so one needs to critically study that judgment. But for instance, Nnamdi Kanu was accused or charged for inciting violence. Now, common sense dictates that when you say that somebody incited the violence, the question arises, who was incited to violence? And that person who was incited to violence, did he actually carry out that violence? And was the act of violence that that person carried out a direct correlation or a direct result of the incitement? You have to, it is a thread, you have to link it Okay, and from my little grasp of what transpired throughout the trial, I did not think that there was any evidence linking the broadcast, the incitement, to actual acts of violence carried out by particular individuals, not just a general certain some people did this because. Did any one of them come and say that I was incited to violence because of this broadcast I heard, and so on and so forth? So there are so many issues on which a valid appeal can be predicated in that judgment. That's just the clarification I wanted to say. But it would have been a lot easier for a lawyer if a defense had been entered along these lines from day one, so that during the trial you puncture these things, and then at the appeal stage you bring out these deficiencies.
I mean, there's so many questions. While Justice James Omotosho read the judgment yesterday, there was a bit of confusion for those of us who were listening to it, because he mentioned that the convict is hereby sentenced to life. And I'm reading a copy of the judgment, the 144-page judgment of the Federal High Court in Abuja. On each of the counts he counted 1, 4, 5, and 6, but he noticeably omitted 2. So when we're trying to come up with the story, we were wondering what happened to the second count, right? But looking at the judgment now, you see that count 2 is also included in one of the counts for the life sentence that, of course, he was given. So that clarifies it. No more confusion there. But there are also many questions as well. During that the court judgment, the case of his broadcasts, the broadcasts he made were continually referenced. His incitement of the sit-at-home directive in the region that stalled activities was also mentioned. They also accused him of having a role in the NSAS incident. And most of the broadcasts, they quoted things that he said in those broadcasts that could have also incited the public, right? So, I mean, they say journalism is the first rough draft of history. Anything I say today or that Nnamdi says today could be played back tomorrow, that you said this. And those things are hard evidence that even members of his group assisted to share. People listened to that. People worshipped that Radio Biafra. They listened. I mean, they say that sometimes the things you say with your mouth could be more powerful than the things you can use your hands to do. Is that what this judgment is saying? Is the mouth really more powerful than the hand?
Number one, you have to, the first query we have to undertake is, where was that? The judgment was very replete, about broadcast, but the judgment was very silent about the venue of those broadcasts. Where was that broadcast made from?
In the United Kingdom.
In the judgment. Where was did you read anywhere that judgment where the venue of that judgment, or the venue of the broadcast was stated? I never saw anywhere where the judge made reference to the location, the originating place, the place from where the broadcast was made. That is one, Then, very correct assessment that you made. The mere fact of making a broadcast, that is speech, has now been criminalized. Okay? And to now say that because you made a statement, because you made a broadcast, it is now treason or terrorism. It's I don't want to use the word that originally came to my mind, but it's stretching facts and law very far, very, very far, to come to the conclusion that a broadcast is terrorism. It's stretching the facts and the law to a very, very ridiculous extent. I just want to stop it there. It reminds me of Alice in Wonderland. As a character in Alice in Wonderland, he uses words, and the other person say, but this doesn't mean that. He said, when I use a word, it means what I want it to mean. Okay? So when the federal government of Nigeria uses the word terrorism, it means what the federal government of Nigeria wants it to mean, not what you think it means, or what any ordinary, reasonable person thinks that terrorism means.
When the medium of broadcasting is brought into the equation, is it as much of where you are broadcasting from as to where the wavelength of that broadcast is getting to? For instance, we're broadcasting from Enugu State, but this broadcast is reaching people in different areas. Whereas you use your mouth, anything we say here is between all of us here and ourselves. But once we turn on this transmitter, it becomes global, regional, some would say national. Is that why it was omitted in the judgment? Did it really matter where he was broadcasting from, at the risk of upsetting some collective sensitivities? Barrister Chidi, over to you.
I don't think the place where a broadcast actually originated negates, the facts or the allegation you are trying to place upon the person who have made the broadcast. But rather, the thin line there is that, were we able to pinpoint a particular person who acted as a result of that broadcast here? That's the lacuna. That's the incommunicado in the judgment. Because a broadcast was made, certain things were said, and now you now presume that those things that were said was actually what made some people here to act. But there was no linkage. There was no core evidence. There was no material evidence to show that, yes, you didn't bring people who acted, or even no one from the NSA has testified that he or she was, incited by Mazi Nnamdi Kanu. Nobody was from the other side who came and said, I was incited.
Okay, so let me come
Have
back.
you seen it?
Let me come back to Barrister Ejike quickly. Just a quick one. Before Nnamdi Kanu's arrest, what was your assessment of the broadcast on Radio Biafra? Let's gain your assessment. Did you ever listen to Radio Biafra? What was your assessment of the messages passed on Radio Biafra?
I did listen to a couple of the broadcasts, and my personal view is that they were rather extreme. They were extreme, they were truthful, quite all right. They were very historical, packed with facts, but rather extreme.
What do you mean by
The
extreme?
mode of
What's
presentation.
Extreme? What's extreme?
The mode of presentation was rather extreme. What I mean by that is that when you make a fair comment on the state of Nigeria as it is, and the historical imbalances in Nigeria, which has been Mazi Nnamdi Kanu's forte, he's been highlighting the issues of inequality and the structural imbalances in Nigeria as it affects the southeast, and the Biafran enclave, But what I meant by being extreme was that beyond the fair commentary on those things, he now descended into vituperative outbursts on certain individuals, And to be quite frank, between you and me, let's face these facts. These were part of the reasons why he's here now. Okay,
Character.
He made certain statements about the late head of state, Mohammed Buhari, which were very pejorative. Made certain statements about the current president, Tinubu, which are extremely pejorative. And no matter how you may want to look at, that's why I said, from the onset, that this trial is not about law. This trial is not about law. It's about other issues. Okay, so these two individuals, the late president and the current president, will you blame them if they want to extract a pound of flesh using the apparatus of the law? Will you blame them? You may blame the judiciary for lending its apparatus, to this charade, But you will not blame these two individuals, So that's what I meant by.
The impression you're creating, I would like to leave Nnamdi to handle this from here, is that both parties had a medium. So Mazi Nnamdi Kanu had the broadcast medium, and if your allegation is factual, if it's true, which I can't testify to, I'm not a judge, then that means that if the federal government is truly weaponizing the judiciary, then the judiciary becomes the weapon or the medium of the government. So they both have mediums, right?
I'm listening to what Barrister Ejike is saying, and I also want to go back to that issue of, the location of where it was broadcasting from, because one of the outcomes of the trial was that they said they are forfeiting the transmitter to the federal government. I've been in media operations for over 2 decades. I know the maximum reach a radio transmitter can get. And if they took a radio transmitter from him, as they say, then I think it's imperative they tell us where he broadcasted from. Because without saying where he broadcasted from, you cannot say where he was broadcasting to. Radio transmitters have finite ranges. Even if you have a 7 kilowatt transmitter, from Enugu, you will not get to Lagos. So they have to tell us where he broadcasted from. If not, you cannot say who he broadcasted to, which is my point in this. Which is why when Bright Ejike mentioned where did he broadcast from, that has been rolling in my mind since that really, if in the whole judgment you are accusing somebody of making a broadcast and inciting violence, and this is not me disparaging the judgment in any way, it's just me as a non-legal person asking a question. Who was incited? Where were they when they were incited? Can you prove that the broadcast was made in this location and the transmission was able to reach these people who were incited?
Don't you think if someone is denying that there was no broadcast, the issue of where it was made or when it was made will not come into foul play? He did not deny that he's not the one who made the broadcast. All the things they played, including the ones he was inciting people, telling people to do one or two things, he never said, I am not this person. He never said, I did not do that.
My point is not that he did not broadcast.
There are two arms to this. Where the broadcast was made and whether the broadcast actually incited people. So, I think we should focus on that one.
Nathalie mentioned something. If we speak here, we're speaking amongst ourselves.
Mm-hmm.
If I come here and I say, I think that all my guys now to wake up this morning and go and start randomly slapping people. It's different from if I call them and say, guys, I bet go out, people don't like you, get up and start slapping them today. I'm serious. I didn't even say, why? Why? Because they don't like you. They even abused your mother. They abused my mother. I've incited them. So my question is, we're not denying Nnamdi Kanu did not say it. But have we, like Bright Ejike was asking, have we proved incitement when one, we cannot prove the location of transmission?
Do you need the location of transmission to prove excitement?
Yes, you do.
No, you don't.
Who was incited?
I don't think you do.
No, let's just do this for 1 minute.
Who had access to it?
Who was incited?
Who had access to it?
Who was incited?
The people who had access to it.
Who was incited?
The people who had access to the broadcast.
They gave cases of people they claim were incited by him. These things happened in Enugu, in Olu, in all those places. But you're saying you caught him with a transmitter in a hotel in Ikeja. There is no way he could have broadcast with an FM transmitter except you're saying that he had a shortwave transmitter, which is not possible.
I can't go into that.
If you see the size of these things, the only portable transmitter he could have had is an FM transmitter. And there is no way an FM transmitter in Ikeja would get beyond even Ogun State. And even in Ogun State, you would not get beyond Ijebu. That's, you might do Egba, Ifo, Obafemi Owode. You will not get beyond any Ijebu province. So to say that somebody in Olu, somebody in Enugu was incited by a broadcast with a transmitter in a hotel in Ikeja, that already, I think, if Nnamdi Kanu had a legal defense,
have you forgotten the power of the social media?
This conversation
could have been struck.
This conversation, I would have to be honest.
Have you forgotten the power of the social media?
I'm not disputing, but
I can amplify something to just you, and you can put it to Twitter, and the whole world can hear it.
My question
so it's not about the mileage of the transmission or the transmitter.
Am I responsible for the amplification?
Eh?
Am I responsible for the amplification?
No. It's about the content of the broadcast.
Am I responsible for the amplification?
It's about the content of the broadcast.
Barrister Chidi, make your point.
Barrister Chidi,
can you state where you stand on this clearly?
If I record an explicit video, very explicit, right, and somebody goes and puts it on social media and underage children see it, is Nnamdi Obaya guilty of putting explicit videos for underage children?
Number one,
I made it for over 18.
Number one, if there is a law against making that sort of videos in Enugu State, and you made it in Enugu State, you'll be liable for that law of making. You'll be liable under that law in Enugu State, which criminalizes making that type of explicit videos.
Yes.
Now, if somebody in Kogi State watches it, and there is no law criminalizing making explicit sexual videos in Kogi State, the court in Kogi State cannot try you for making that law. If they want to charge you for making, they have to charge you for making. 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 They have to charge you not for watching, not for sending, not for broadcasting. They want to charge you for making, because as a charge that you broadcast. They want to charge you for making that video. They have to take you to the place where you made it, where a law criminalizes.
So my question is, the charge here is not making the video. The charge is that, just like you said, the incitement.
That's a charge for broadcasting.
You know, you said the incitement.
Look at that charge.
No.
That you broadcast, that you, by reason of your broadcast, incited.
Inciting is a verb.
Yes.
It's an action.
So number one,
they have to be two. They have to be
broadcast. The broadcast, you know, when you, because these are.
But there have to be two parties for incitement.
Yes.
The inciter and the incitee.
Yes.
So that's why I brought up this question. That if I made a video, explicit video, I didn't make it for underage viewers. I made it for adults. Now already, even if, let's say there's a law against, I'm using it because there's clearly a law against showing explicit material to underage children. If somebody, an over 18 person who has access to my video, goes and puts it where under 18s can watch it, am I guilty of providing explicit content to minors?
Our discussion.
So
that's what I'm asking. You mentioned the social media.
Okay.
Yeah.
Is it Mazi Nnamdi Kanu,
Mr. Nnamdi,
who by social media
we're talking
transmitted it, and can it be proved that that social media was the person that was what incited this?
Let me now tell you this one way.
That's what I'm asking.
It goes back down to the definition of broadcasting. Right. So broadcasting is when you use a medium to transmit a message to a large, heterogeneous, diverse audience, faceless audience, which you can't really, you don't know who is listening to your broadcast at every given time, right? The only feedback you can get could be physical, verbal feedback or non-verbal cues. And it's only that you now register if the message was effective or not. So when you're dealing with a large, heterogeneous, faceless audience, how do you single out the one person who was incited?
Exactly.
So
Thank you.
So the question now is, I really want you to make your point. Did the judge have to know who was incited to deliver the verdict, judging by the utility, the use of a medium that indeed makes it a broadcast?
If you give a judgment that someone's personal broadcast, let me say it now, irregardless of the place where he originated the broadcast, have caused, have incited, is a verb, is an action word. Yes. It has made people to do something wrong. Even if in that region, certain elements of people did something wrong, it does not suffice. It does not suffice. You must link that particular broadcast to a particular individual.
So they mentioned the issue of burying a commander with human heads, and they said they caught people with human heads. Later, that Nnamdi Kanu broadcast that a commander who was killed should be buried with human heads. That he broadcast that he should be buried with human heads as a warrior, and that they caught some people with human heads, and they said they had gotten 20 human heads, and we are going to use those human heads. So my question is, did those people? Where is the evidence for all these things? I keep asking this because Nathalie mentioned that when you're broadcast is not usually two-way communication. It's not direct two-way communication. It's mass media.
Okay.
It's an extended one-to-many. Now, in a case like this, should you not be able to prove beyond reasonable doubt for such a weighty case? Is beyond reasonable doubt not required?
So let's look at another feedback.
I just wanted to point out very quickly that there is a difference between an act likely to and an act that actually
occurred.
Did.
So let's look at
when you are charged or you're accused of a broadcast that is likely to incite people to violence, very different thing.
Is that not a minority?
Very different thing. The weight of evidence, the amount of evidence needed to establish that is very different from the amount or quantum of evidence needed to establish a charge that you actually incited.
So let's
they are charging him with intent.
No. Let's talk about
They are charging him with actually inciting.
So let's
When
look
I'm
at
saying
one
that
thing
there's
that
a
was cited
distinction
in court.
between a broadcast that is likely to incite
There was
and a
a
broadcast that
particular-
actually incited.
There was
And they're,
an incident.
and they're
Let
charging
me
him
just make
with
this point. Let me just
they're
make this
charging
point.
inciting.
Do you think the evidence is sufficient?
Can I add
for
something?
this charge?
Can I add something to what he just said?
So let me just throw in
It
something.
would have been
okay?
totally
so one thing
different.
that was cited was the case of sit at home. The question now is, who told the Southeast to sit at home? And did they do it? Did they provide feedback by sitting at home? Barrister Chidi.
You can't ask me that question because I don't know. Okay? I don't know who told the Southeast people to start sitting at home. I wanted to go to work on a Monday. All I heard that today you're not going to go anywhere. I said, who said? They said, IPOB. That was how I got to know it. Personally, I am reporting to you directly now. I don't have any contact with Mazi Nnamdi Kanu. He never said anything to me. But I wanted to drive out from my house and I saw everywhere was empty. And I asked my neighbors, what is happening? They say, IPOB said that today it's no movement day. And that was how it got sunk into my subconscious.
And
that on the Mondays
if I remember clearly, the sit at home started from every day Mazi Nnamdi Kanu was going to court.
supposed to go to court.
So he couldn't have been the one giving that order. Then later, the sit at home became a Monday thing. And then Simon Ekpa took it over. And at a point, we had a written letter from Mazi Nnamdi Kanu saying people should stop sitting at home on Monday. And we had Simon Ekpa quash that. But sit at home was a charge brought up in court. And Simon Ekpa is still in Finland on what Nigerians believe is terrorism charge. But many of us who have looked deeper.
See, I was following Mazi Nnamdi Kanu case very well. You remember that Agabi was representing him, even up to the point where the prosecution closed their case. You understand? One thing that really, really made me, triggered my interest was when they entered a no-case submission. Do you know what it means? It means that these legal juries have examined the strength of the case of the prosecution, and they think that it does not worth it while. So that's why they entered no-case submission. So if a no-case submission have been entered and a robust defense have also been entered, do you know, minus Mazi Nnamdi Kanu's character, do you know, I don't think that he would have lost that case. And I don't even think that he would have gotten a life sentence.
But you're saying, Senator Baribi and others saying that the judgment was preconceived, that regardless of what happened. And then there are those who say the way Justice Omotosho was reading the ruling, like it was his first time of setting eyes on it. I mean... Yeah, I noticed
the structuring and the inconsistency. He wasn't flowing with the judgment.
I sat in Justice Ogbuago's court here in Enugu, and I've seen him read. And I've seen him even stop sometimes and, when he wrote something, say, hey, this thing, I want you to also... You can see that he's reading something he was responsible for, the compilation of.
Yes.
As against somebody who is reading something like they just gave them. And that was the comment I got yesterday that this reminds me of the justices in 2023.
Yes.
They were reading something they were seeing for the first time.
Election judgment.
Yes.
Clearly, anybody who says that judgment was preconceived cannot be totally far off the mark. Cannot be totally far off the mark. In the sense that when you look at the trend of events, even in an ordinary, any ordinary person, from the moment that Nnamdi Kanu refused to enter his defense, would have started writing that judgment. Okay, so it was not the day the matter was adjourned for judgment that judgment was commenced. That judgment had already been, the process of that judgment had commenced even before the date for the entering of judgment. Now, I say this with all due sense of responsibility, okay? I'm not to be interpreted as casting aspersions on the integrity of the judge and all that, but there was no other judgment that could have been read apart from that judgment. Now, the question is, was it written by Justice Omotosho? I do not know whether it was written by Justice Omotosho or not. The comments you make allude to the fact that perhaps it was not written by Justice Omotosho. That is reasonable, looking at all the surrounding variables. It is very, very reasonable for anybody to come to that conclusion. And I alluded to it also when I made my comment about the vituperative comment made by Nnamdi Kanu on the person of the late president and the person of this current president, and when you tie together all the comments that people have been making about the judiciary, including the recent development on your mandates and all, everything, and you said the weaponization of the judiciary and all that, clearly, why I said I was upbeat about the judgment is that this judgment, perhaps unwittingly, is further exposing the rot in the structure of Nigeria. The man Nnamdi Kanu set out to point out the inadequacies, the imbalances in the structural configuration of this entity called Nigeria, where we are supposed to have a federation, a federal setup, but what we are running is a unitary setup, a unitary federal republic of Nigeria. Now, in the bid to debunk that, we are further exposing other inadequacies, okay? Systemic. For instance, we are showing the inability of the judiciary to rise up and firmly display its independence. Firmly display it. It's not a question of affirming independence, but displaying it. The lawyers are very fond of saying that justice is not just about being done, but about being seen. The perception is key.
Right. Unfortunately, we're out of time now. Thank you so much for your valid input in this conversation. It cannot stop. I mean, I have so many questions too. But what I would like to chip in line with what you've said is independence of the judiciary, but then you see the FCT minister
immediately after the trial, I'm agreeing with you. Immediately after the trial, went to go and inspect judges' houses.
Yeah, inspecting judges' houses. I think it was before
and the court
trial.
of appeal.
Yeah, it was before the trial. We saw the photos making the rounds of him inspecting the judges' quarters. So it's quite a scene, isn't it, in Nigeria? But we'll continue to discuss this situation. Thank you once again for joining, and we'll assess all sides. Okay, yes. We'll assess all sides of this debate.